Good day and welcome to The State. The show is brought to you by Christian Service University in Kumasi, and we are going to have an interesting conversation this afternoon. My name is Gabriel to Ankrah. Stay with me. I'll be back with the details.
The Christian Service University, a fully chartered private university in Ghana, is inviting applications for admission. Undergraduate programs include BSc Nursing and Midwifery, Computer Science, Information Technology, Bachelor of Business Administration, BA Communication Studies, Planning and Social Development, and Theology with Administration. Postgraduate programs include MSc in Accounting and Finance, Monitoring and Evaluation, Corporate Planning and Governance. We have MA MPhil Communication Studies, MA Christian Ministry with Management, Event Management, MPhil English and Mathematics Education. With quality, faculty and state-of-the-art facilities, we blend academic work with entrepreneurial mindset in all our programs. For more information, please call 0246 275375, 0240 154825, or 0244 596603, or visit our website www.csuc.edu.gh. CSU is located at Odeneho Kwadaso on the Kumasi-Obuasi Road, 100 meters off Star Junction. Choose CSU today to secure the future of Africa.
And to make him better known. That's
Sorry, not sure.
Wake up to a purposeful day.
Get ready for a transformational morning experience.
Sorena Shrine is here to build our spirituality, mental and physical well-being.
Through positive, inspiring actions and stories.
We bring you exciting activities and conversations that develop us as a people and as a nation.
We take a look at the trending issues in Ghana and the rest of the world.
And we also review the impacting stories from our local newspapers.
Every morning, we bring you stories of hope, change, and renewal.
We empower you through the Word of God and provoke you to live the purposeful life destined for you.
Join us, Anita Kwaku
and the Reverend Ajika Vincent Agbamanya, Monday to Friday from 5:30 a.m. to 10 a.m. as we take you on an inspiring journey, live and exclusively on WTV.
You may also join us on Facebook at WTV Ghana and on YouTube at Wesleyan TV Ghana.
Sorry, not Shrine.
Wake up to a purposeful day.
Sorena Shrine is brought to you by
Danwell Insurance, Multi-Credit Savings and Loans,
and the Methodist University Ghana.
Welcome back. Let us do W Briefs. On this segment, what we do is to give you an executive summary of the topic for discussion for the day. We give you a snapshot of what to expect as we delve into the conversation. So, the democracy of Ghana is evidenced by the alternations of the major two political parties, that is the NDC and the NPP. There has been smooth and peaceful transition between these two parties. Parliament has been at the heartbeat of this democratic process. And then that has made us the envy of many nations in the sub-region. The 8th Parliament of the 4th Republic of Ghana, however, has introduced certain interesting dynamics into our democratic process. The New Patriotic Party had 137 seats, NDC had 137 seats, and an independent seat. This gives it what has become to be known as the hung parliament. That is the dynamics that we witnessed in the 2020 elections. The 8th parliament, however, has not been without controversies. You remember on the 7th of January, when they had to elect the speaker, you remember, it wasn't a sight that we really want to recall. The latest is the case of 4 MPs who are fought to run in the next elections on different tickets. They came into parliament on sole political party tickets, but they have had a change of mind and they want to move at what we call, they want to switch carpets and then move to other political parties or independent tickets. The Speaker of Parliament made a pronouncement after the minority had informed him in the course of the discussion. Previously, the minority had mentioned on the political platform that they were going to raise this issue on the floor of parliament, that some of our colleagues have changed their minds. They want to go solo and they want to leave their parties that brought them into parliament. The speaker asked for 2 more days so that he could reason and then come out with a ruling. On the 17th of October, he made a pronouncement. This pronouncement were hinged on 3 main blocks. 1, the Constitution of the Republic of Ghana, the Standing Orders of Parliament, and precedents. Of course, it has happened before. In the 7th Parliament, which was chaired by Professor Michael Quay, there had been a similar incident. So, definitely, he was not bound by it, but he ruled based on that. The fact remains that as it stands now, per Ababagbe's ruling on the 17th of October, we have 4 seats affected. 3 of these seats belongs to the NPP. 1 belongs to the NDC. So this is the current status of the seats in parliament until they resume or they return from their break on Tuesday. The NDC has 136. The NPP has 135. This time around, no independent candidate. So what it means is that there is a shift of power. The minority is saying that tomorrow in the chamber, they are going to occupy the majority side of parliament. But quickly, the minority ran to the Supreme Court. Mind you, prior to that, the same majority has already asked for clarification on this switch of the candidates to other parties on other tickets. Then, after the ruling, went back to the Supreme Court to ask for stay of the Speaker's ruling. And this, the Supreme Court granted on the 18th, the following day. What we are asking, the big question, is that will Parliament assert its authority over its own eternal proceedings? Are we going to see a judicial legislative standoff? I'll be back to introduce my guest. Don't go anywhere. Said.
nyansa ejian mpenina no anaya gye mpenina no ti ba bibiara mpenifo ahia na yesua adwene no ne open nyansa no oben wa ode agudie kira adwene mu agudie ene kofie penu sa adwene nsemu mu odo nzemporo nsemu a yetie bobra ekoyie frase efifrito ne open nyansa no omengwankwa enu ase ne mpani so ayadwene ne be nhira amano ene ni nchirima yada mo ase
da impanyini inso ayadwene jemre na hweyen memninde ne memninde bia anopa no wotwe wo Wesleyan television so.
Welcome back. On the stage this afternoon, we are looking at the declaration of the 4 vacant seats in the legislature, and then we're going to explore the fallouts from the Supreme Court ruling, and then its implications. It's going to be an interesting conversation. I promise you that. So stay tuned and make sure you follow closely so that you appreciate and understand the issues so far as our democratic processes are concerned as a country. The show is brought to us by kind courtesy of Christian Service University. Christian Service University is an evangelical liberal arts institution established 50 years ago to train men and women with ethical values for transformational leadership in Africa. Admissions for the 2024-2025 academic year is in progress for undergraduate and postgraduate programs. CSU offers dynamic academic industry-driven programs in nursing, midwifery, business administration, communication planning, and computer science. For more information, please contact our admission relations officers on 02462 75375, 0240154825, 0244 596603, or visit our website on www.csu.c.edu.gh. Choose CSU today to secure the future of Africa. CSU, the university of choice. I'm joined in the studio by a private legal practitioner, 𝗟𝗜𝗩𝗘. Said, welcome to the state. We'll also be joined online by a political science lecturer at the Kwame Nkrumah University of Science and Technology, Professor Kwesi Amachi-Boateng, in the course of the conversation. So it's an interesting conversation. We are happy that we have Said in the studio. So the legal content, rest assured. Said, your preliminary comments on the development so far as you've monitored.
Okay, all right. To begin with, I would say the incident that happened last week, Wednesday, was unfortunate. It could have been avoided. The Constitution has anticipated such things and then provided remedies for all these things. So, in my opinion, it could have been avoided if we had gone strictly according to the Constitution. So, if you ask for my preliminary comment, that's what I would say.
It could have been avoided. That's unfortunate. So. Which of them? Because these people thought that this has happened before. There have been the situation where the then speaker has ruled that because you switch carpet or you cross carpet, let's apply the standing orders or even the Constitution as it says. So they were just more or less reminding him or going back to take what happened the previous parliament.
That is so per the facts you rightly stated. But then if you go through our Constitution, specifically Article 99(1)(a) of the 1992 Constitution, states that the decision as to whether a seat is vacant or not, or a member of parliament has vacated his seat, is a sole responsibility of the judiciary. The High Court has the jurisdiction to make such determination, and not political actors like the speakers of parliament. So if we had gone strictly according to the 1992 Constitution, specifically Article 99 of the 1992 Constitution, we could have avoided this thing in the past.
But Said, interestingly, the same Constitution, Article 97, Clause 1, G and H, is what this whole debate or this whole issue is hanging on. And that rightly says that the G of 97 Clause 1, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or then the H says that if he was elected a member of Parliament as an independent candidate and joins a political party.
Okay, so this should be the fact, as we were told, that some 4 members of current sitting members of Parliament have declared their intention to contest on the seat on the ticket that brought them to Parliament. The Constitution, per the provision you just read, looks at the current circumstances, not the future occurrence. It could be that yes, I have declared I went to Parliament on ticket of Party A, but then at the next sitting of Parliament, I would want to contest on the ticket of Party B. But as I have filed my nomination to contest on the ticket of Party B at the next sitting, still I owe my allegiance to the the party that brought me to power. In this instance, none of the parties, none of the Cynthia Mamle Morrison, Andrew Amwako Esiama, none of them have said that they do not owe allegiance to the respective parties that brought them to Parliament. So the Speaker, as I said, this is not a political question. Let me read the provision of Article 99.
Yeah, the 99 you referred to.
This is the heading. The High Court shall have jurisdiction to hear and determine any question whether A person has been validly elected as a member of Parliament, or the seat of a member has become vacant. So these are the facts. If a seat is presumed to be vacant, the Speaker has no jurisdiction to make pronouncement on such. At best, what could have been done was that even some legal luminaries even have the opinion that we shouldn't have even invoked the jurisdiction of the Supreme Court
in the first place.
Because
it's clear.
Article 99 is so clear that the High Court has jurisdiction on such matters. Whether a person has been validly elected as a member of Parliament, or whether or not a seat has become vacant. If we should leave these things to political actors, as we really stated, because in the past it was done, so we would follow precedent. Whether the precedent is good or bad, we would still follow it. Which will not other work for the.
It's interestingly, how come that we, the majority, the masses who are going to vote, of course, we didn't go to Mokola. We are not lawyers to be. We have those laws at our fingertips. Both parties, surprisingly, have distinguished legal practitioners, and they come on TV. How come nobody made reference to the 99, but everybody is hammering on the 97, 1, G and H?
Okay, so a friend would say interest. Everyone is advancing their interest, but then, as lawyers, it's even wrong if you are making your case in court, and then you know that what you are saying is not right, and then what your opposing counsel is saying is the right principle of law, or even if what he is saying will inure to your benefit, you still have to correct him. You do not assume the fact that because if I should correct him, it's going to go against me, so I should keep mute. No. So all what I'm saying is that both legal luminaries on both sides were just advancing
their interest,
what will suit their interest,
political interest.
Because as is stated, before 2000, Andrew Esiama, there was one Dr. William Akoto. He contested on the ticket of NPP during the 2000 elections. And then going into the 2004 elections, he contested as an independent candidate. No issue about his candidature came up. Because as at that time, everyone knew that he hadn't crossed carpet. He went to parliament on the ticket of NPP. He hasn't denounced his allegiance to the NPP. He was still in parliament, goes to parliament, conducts business on behalf of NPP. But then he said, I'm filing for the 2004 elections as an independent candidate. He did, and then he won. Our current deputy speaker, Joe Wise, 2009, entered parliament as an independent candidate. And in 2012, contested on the ticket of NPP and then won. Recently, MTN, Michael Tenyanyanu, MP for Manya Krobo, is it East or he was in parliament on the ticket of NDC. And then, prior to 2012 elections, contested as an independent candidate, and then he really won. I'm giving you all this background. In all this situation, nothing came up about their eligibility to contest because they are leaving one ticket to the other, so their seat has become vacant. No, this is even a human rights issue. Is it Article 112 of the 1992 Constitution states that 3 months before a general election, you don't conduct a by-election. So if you are to declare some seats vacant, meaning they will not have representation in parliament.
This argument, I will come in to ask you about representation in parliament, because then the Santrophy Lolobi, this thing comes. Now we'll look at it as a speed of justice. How the wheel of justice runs. So we'll look at the speed. But you mentioned the other argument too has been that, let's look at the doctrine of separation of powers. It is argued that the judiciary is usurping its powers by coming into the space of parliament that has a standing orders to run by. Has the doctrine of separation of powers been violated in this case?
Not that I think of. Separation of powers doesn't mean the three arms of government do not depend on each other. They complement each other in their line of duty. So, in a celebrated case of Tufo versus Attorney General, the Supreme Court made mention that the activities of Parliament is a closed book, meaning Parliament is a master of its rules. What happens on the floor of Parliament cannot be questioned in any court. But then the end product of Parliament is subject to the court jurisdiction. So, for instance, making laws, the Constitution has stated the procedure to go through. If Parliament do not follow the procedure, no one can question them. But then, if the law, the bill finally becomes a law, then the court will assume jurisdiction to make pronouncement on it, whether it was validly made or not. So the issue of whether the executive is usurping the power of the
legislature.
The legislature, I don't think that is the issue. That is the issue now, because they feel that the executive feel that they have the numbers 137, so to speak, plus the independent candidate, so they can do certain things and then undo certain things. So by their activities or by their conduct, they feel we can push our agenda. And then by their workings of Parliament, their rules state that it is the majority leader who presents the business of the government, and then so have you. So what the executive feels that it has to be determined on the floor of Parliament. That is what he will bring. But strictly speaking, I don't think there is any conflict with regards to our separation of powers. Because although both or the three arms of government they are independent, independent to say, but then
dependent on each other because their functions.
Exactly.
Viewers, you are still on the state, and this afternoon we are looking at the 4 seats that were declared by the Speaker as vacant, and it's aftermath the declaration of the Supreme Court also, and then we are exploring to see the implication as we go forward, because tomorrow is when they return to Parliament in the chamber. Who takes the majority side, who takes the minority side? Are we going to have that ugly sin that we had some time ago? Will there be legal remedies before even Tuesday, before we go into tomorrow? Fortunately, we have a legal brain and a legal eye in the studio, trying to educate us and get us to understand and appreciate the issues. Private legal practitioner Said Hafiz, who is with us in the studio and then helping us to appreciate. Said, I mentioned earlier on that the speed at which the Supreme Court gave its ruling, and the NDC have been arguing that 4 years we have had a case before you. Don't you think that the people in my producer was Santrofi Lolobi Akpafu in that area, haven't they been denying representation and Parliament? It's also been argued that it could have been avoided if Supreme Court had gone about it in a different way.
Okay, all right. So
I'm talking about speed.
Exactly. Yeah. So this is an ex parte application.
Yes.
And then ex parte applications are part and then parcel of our procedure. And then a ruling on an ex parte application ordinarily lasts for 10 days. So after 10 days, you would have to put the other party on notice. So if, for instance, something is being done if for the lack of better word, let's say something urgent is happening, and then if you do not seek the intervention of the court, the harm or the damage will be done by the time your case will be heard. So the rules provide for you to go to court ex parte at the blind side of the other party. Once you secure the ruling, then usually the ruling lasts for 10 days. So
this ruling, as of October 18th, yes, we should start counting.
Yes,
10 days after.
Because it's an ex parte application, and then if you should see, or if you should have, if you had read the ruling, you would have realized that yes, it is supposed to last for 10 days. So after 10 days, you would have to put the other party on notice, so that both of you will go to court and then argue your point out. So based on that, the court will make its ruling or decision. With the issue of SAR is a very sad situation. As I rightly pointed to you, Article 112, Clause 6 of the Constitution says that, or Article 1126 says that everyone shall have representation. But then this is the case whereby a whole term of Parliament is coming to an end, and then some people have been left out, no representation, and then the agency at which other cases are being dispersed, it's a worry.
I was thinking as a layman that it because of the gravity of the situation and the issue at hand, if Supreme Court doesn't step in, we could have a recurrence of what transpired January 74 years ago, which we don't want to have. Maybe can't the discretion be used by judges in determining the course of our political future?
With cases on which borders on political interest, I would say all of them are of paramount to our nation's development. For instance, with this anti-LGBT bill, what is preventing the Supreme Court from expedited action, as in hearing the case on an expedited manner? when the legislature has done its duty, passed the law, gone through the process, now it's left with the president to assent to it for it to become law. Now we are being told that an action is pending in court. So before the action is determined, the president cannot assent to it. You see, these are all legal gymnastics. As you rightly stated, the wheel of justice grinds so slowly, to the extent that last week I was making this argument on social media. Someone asked me, do I have any reservation about the ruling of the Supreme Court? I said no, I do not, because it is part and parcel of our procedure. But then, the urgency at which they dealt with the matter, even per their work schedule, my lords, the justices do not sit on Fridays. But then we were even told that the process was filed either a day before or on the morning, and then the Chief Justice empaneled justices to hear the application. So, as we rightly stated, all the cases are of national interest. We can assume expedited action for such cases. The e-levy cases are in the back burner. Anti-LGBT, SAR, then we are still on. But then a process was filed a day before or on the morning, and then the Supreme Court, which usually do not sit on Fridays, was quickly empaneled.
But the law is in their bosom, so they can. Let me bring you quickly back to the ex-parte application. The argument is that it states that until the determination of the case, apart from the 10 days, let me say the moratorium that is there, that until the case is determined, some deem it like the ruling has already been given.
Oh no. So with ex-parte applications, the court do not go into the merits of the case because it's a one-sided argument. You would go to court, make the argument that because of the urgency of the matter, so if he is not stopped before the court will sit and then hear the case, the harm has already been occasioned. So you would want the status quo to be maintained. So after the interim 10 days, both parties will come and then argue their cases out, argue their point out. So based on what you argue, that is what the court will base on and then give its ruling.
So it's one-sided.
One.
Did the speaker err?
As I rightly stated, as lawyers, we deal with precedents, stare decisis, really. So, and then the speaker, as I stated earlier, such cases on whether a seat is vacant or not is a judicial matter, should be left with the judiciary to handle. If you leave such cases with political actors, definitely they would want to appease their base because it was done in the past. So same has to be
applied in this situation.
So you see, my issue is that yes, Right Honorable 𝗟𝗓𝗡 erred in the past. The current Speaker of Parliament, Right Honorable Bagbin, had the opportunity to correct
it.
What Professor 𝗟𝗓𝗡 did in the past. Because I indicated to you, Article 99 is so clear on it. If you look at the the heading, determination of membership, the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant. So why should a Speaker of Parliament assume the jurisdiction
Are there legal remedies that the speaker can, because they are to go tomorrow? Can the speaker's lawyers do something about the declaration by the Supreme Court? Or he can call the bluff of the Supreme Court?
As we rightly stated that the activities of Parliament is a closed book. That what happens in Parliament cannot be questioned in any court. There are rules of procedure. But one will argue, making a ruling does not fall within the rules of Parliament. So if what Parliament did affects some people, so to speak, because it affects people in certain constituencies, 4 constituencies to be precise, then they were right in going to court to assert their right. But then in doing so, the Supreme Court has made orders that you should stay your ruling until further notice. And then there are other arguments as to whether what the ruling of the speaker, can it be stayed in any court? Because you only stay an order from a competent court, an order, ruling or judgment from a competent court of jurisdiction. The speaker did not assume any jurisdiction as a judge. If he has given ruling on the floor of Parliament, can the Supreme Court stay that order? It's a question that people are asking around. Then I want to associate myself with the question that on what basis do you want to stay the ruling of the speaker? And then, as I said, the ruling affects some people, so
viewers, is becoming interesting. You are getting the various legal angles to what the developments have been so far regarding the seats that have been declared vacant by the Speaker of Parliament. We've been looking at this issue, and I will take a quick break. When I'm back, we are going to look at the implementation of the ruling from the Supreme Court. Can the Speaker of Parliament refuse to implement? If he does, what are the implications for us? Stay tuned, don't go anywhere.
The Christian Service University, a fully chartered private university in Ghana, is inviting applications for admission. Undergraduate programs include BSc Nursing and Midwifery, Computer Science, Information Technology, Bachelor of Business Administration, BA Communication Studies, Planning and Social Development, and Theology with Administration. Postgraduate programs include MSc in Accounting and Finance, Monitoring and Evaluation, Corporate Planning and Governance. We have MA MPhil Communication Studies, MA Christian Ministry with Management, Event Management, MPhil English and Mathematics Education. With quality, faculty and state-of-the-art facilities, we blend academic work with entrepreneurial mindset in all our programs. For more information, please call 0246 275375, 0240-154825 or 0244-596603, or visit our website www.csuc.edu.gh. CSU is located at Odeneho Kwadaso on the Kumasi Obuasi Road, 100 meters off Star Junction. Choose CSU today to secure the future of Africa.
And to make him better known,
Don't call me, oh, don't call me. Ghana for Methodist Asafoma. WTV NMFNMO 5 years. Hooray! Now NM MFNMO Fidida. WTV ADNT. Or yet don't call me promo. And it says, so we are Ghana ni. Now what business? And I do my copia open so one deura. WTV say, yeah, baby chat when you make kuno. And as we got on the no. Yeah, bomu deura now what you mean? 2 weeks at the amount. 1,000 Ghana cedis per. I will bet you. Way a yakwanya. WTV Alpha so at the other was. Say, what time the team? I'm my room pempenswa and never drink. Some promo, ye didn't was make a crack and I Yanunti, one Makua, Opesam Bohun Muntu Tumrika, Namomrai, Fred WTV, Nani Penfoning Como, Emfa don't call me promo 0593 110733 and now WhatsApp 0256 253461. WTV, reaching out to the world.
Welcome back from the break, and you are still on the state. This afternoon we are considering the 4 seats declared vacant by the Speaker of Parliament and the Supreme Court's ruling, or let's say the declaration that they stay the ruling of the Speaker, and the whole nation is just waiting for tomorrow when the parliamentarians get back into the chamber. What is going to happen? Is the Speaker going to disregard the Supreme Court's directive? What will it be like? So the whole nation is really interested in this conversation, and we've been discussing before we went on the break to understand and appreciate what the real picture is, what the real situation is. And the private legal practitioner Saeed Hafiz has been helping us to appreciate and understand what the issues are, and I want to believe that you are now trying to cross the T's and dot the I's so far as this development is concerned. I'm sure the whole nation will be watching tomorrow what becomes of the legislative arm of government in the light of that Supreme Court directive. Hafiz, let's come back to Speaker of Parliament. Can he disregard the Supreme Court's decision?
I don't think the Supreme Court has wide powers. Likewise, Parliament. Supreme Court has the power to cite for contempt. Likewise, Parliament. And I don't think it will be in the interest of the country for both arms of government to be at crossroads. If such should happen tomorrow, it will erode the confidence in our state institutions. So I believe the Right Honorable Speaker will go by the orders of the Supreme Court. But then there is another angle. He is a political person, and then he would want to energize his base or his party's base. So if look at the utterances of the members of Parliament on the side of the NDC, and look at what, before I came online I heard what's it called, Honorable Muhammad Ayariga saying that they will assume their position as majority tomorrow. So they don't want to come as timid to the government or the party in power. They would also want to assert their rights, and then in doing so they will energize their base. On Thursday, when the ruling was made, jamboree on social media on the side, and then on Friday when it was overturned, on the other side too, they celebrated. So balancing the two, I taking into consideration the wide powers of the Constitution, and then on the other side energizing the base of his party members, I believe he can strike a balance and then let cool heads prevail, and then it is only an interim what's it called, injunction. And then let me chip in. This petition or writ which has been filed with the Supreme Court is a right, as in that is how it's supposed to be. That is how democracies develop. You challenge certain laws, and then the Supreme Court to make an authoritative pronouncement on it, and then we will be guided by it going forward. So in the next future, we cannot have this issue as to someone went to parliament on the ticket of party A, and then in the same parliament he said he would want to contest
in
on
the next one, and then
so I believe the Supreme Court will put finality to this issue, and then
I wanted to be speculative and then try to enter tomorrow and say that tomorrow we get there and Speaker and his people trying to galvanize their base says we will disregard it. You are the majority, whether they like it or not. But we are joined on the line by a senior lecturer in political science at the Kwame Nkrumah University of Science and Technology, Dr. Kwesi Amache-Boateng. Doc, good afternoon and thank you for joining us.
Good afternoon, and thank you for having me.
Wonderful. So, Doc, we've had a private legal practitioner with us in the studio, Saeed Hafiz, who has expounded some portions of the Constitution regarding the seats that have been declared vacant by the Speaker. So, your thoughts on the development so far?
Well, once again, thanks for the opportunity. As a student of political science, I see some exciting development in Ghana. You don't always have the situation where politics and institutions, and for that matter, the Constitution, come into this sort of conflict, moving power lines. The Constitution provides a framework within which politics unfold. But here we are. We have a significant political activity. 4 members of Parliament, desiring to participate in the next elections on the ticket of, various political parties. Others also desiring to go independent, and somehow coming into conflict with the constitutional provision. And then the outcome is what we are all aware. So for me, as a student of political science, it's an interesting thing. We teach students of these two issues, politics and then institutions separately. But somehow we also tell them that the two shape one another. And we have a typical case. The lawyer at the studio was talking about it's a typical case of the two shaping one another, such that going forward, if such an issue should recur, we wouldn't have any difficulty understanding what the future action should be. So here you have politics shaping institutions, institutions shaping politics. Institutions have been shaped such that we have a clear understanding of that provision, constitutional provision. And then politics too has been shaped such that political activists, members of parliament, tomorrow will leap before they jump. If, for example, we take such an action and the consequences are bitter, they are not pleasant, then there is it, whether you go ahead and take it or not. So that is it. We have something practical, to use in explaining these two, if you like, issues to students. But then looking at it in the context as things are unfolding, I'm not expecting, confusion tomorrow. I argue that the Speaker doesn't live on an island. He's in Ghana, and he's a lawyer. I like to believe that he's going to be able to navigate, the parliamentary sort of independence and that of judicial independence too, and where the two institutions, when they come into such sort of not necessarily conflict, but they come into closer engagement, like we have on our hands now, we should be able to navigate and then tell us what should happen. So yes, we are strengthening our institutions, we are strengthening our political processes.
Look, are you worried? Are you worried about the way the arms of government, the traditional arms of government, are perceived by the populace now? Because in Ghana here, you realize that I can say, without having to turn my shoulder, that people have lost confidence, so to speak, in the legislature and then the executive. The judiciary happens to be the only one that we can all run to. So in the event where politicians, and I like the fact that your students, when you teach them between politics and the institutions, where the politics of the day decides to more or less, for lack of better words, disregard the judiciary, will it be a pleasant thing to have as a state?
I don't think as at now any politician has disregarded, the judiciary. I don't expect that to happen tomorrow. The statement that came from the NDC camp, to me, is not necessarily disregarding the judiciary. I think they are sort of emphasizing something, that the institution, the parliament as an institution operates, based on its own procedures, and that they take instructions directed from the speaker. I think that is only fair, because that is the situation. So going tomorrow, I believe that the speaker also, who will have to speak to the issue to bring sanity, will do what ought to be done. Because like I said, he doesn't live on an island, and he knows what has been going on. The Supreme Court has suggested that, those procedures be halted. I don't think the Supreme Court is saying that is their final position on the issue. If the things should be halted, maybe they will move further to make a final determination. So why not work with them? I don't see any chaotic thing happening. I don't think the NDC members of parliament have, as we speak, disregarded the judiciary. I don't think so.
I think your optimism gives hope that tomorrow is not as scary as it looks. It's not so scary as it looks.
It shouldn't be.
It shouldn't be. Rightly so.
We are going through procedures that eventually will strengthen our institutions, and then we'll be moving on, a straighter path. And that's it.
Doc, let me ask you something before I come to Hafiz in the studio. Something about political behavior. So Hafiz quoted Article 99, which he says that gives the High Court the power to adjudicate on matters of this nature. But meanwhile, it's the 97 clause 1GH, which says that when a member crosses carpets, he does this and that. That is what lawyers on both sides of the political divide have been advancing for the public to get to know of. This afternoon, the 99 has been revealed to those who don't know that indeed High Court can make a pronouncement on such. Why will we, in the name of politics, not tell the facts as they are?
It's because of the current circumstances. Some people think that Article 97G and H are ambiguous. If you ask me, there's no ambiguity in there, unless you decide to bring one in. And politics is driven by interest. So those who are reading meanings into that, who think that those two provisions are not straightforward, they are ambiguous. To me, they are political. And then my understanding is that the Supreme Court, emphasized the fact that the individuals concerned were not given a hearing, and for that matter, did not, their natural, if you like, this thing, right to be heard have not been respected. If that is the reason he is suggesting that the Speaker's position should be suspended, so be it. So be it. But if you ask me, those two provisions in the Constitution have no ambiguity with it at all. It's people who are doing that interpretation who are bringing in those ambiguities. One such people is Professor Azar. I've read his piece, and I disagree with him. I don't know whether he's a lawyer, he's a policy person, or whatever it is. I'm not a lawyer, but we are looking at interpretation. You don't necessarily have to be a lawyer to be able to understand the principles guiding interpretations of such things. I disagree with Professor Azar.
So let me come to you, Doc. I'll come to you in a bit, but let me come into the studio. Hafiz, Doc mentioned a bit about the ex parte application. He touched on it lightly, where some feel that the rules of natural justice, was not follow procedure. Why didn't you engage me? Is that the case?
Okay, all right. So I believe what Prof wanted to put across was when the ruling, the decision about declaring the seat vacant, none of the MPs involved were given a hearing, and then it's a rule of natural justice that before you take a decision affecting me, give me the opportunity to be heard. So I would confirm whether I have, as in, I have, for a better, lack of better words, I give my allegiance to party A or party B. If I confirm, or even it shouldn't even be a hearing, there is an instance whereby a certain member of parliament on the ticket of NDC crossed carpet to the NPP. He wrote officially to the clerk of parliament, and then the clerk of parliament really took it to the necessary steps, and then the seat was declared vacant, and then a by-election was held. So in this instance, you cannot even claim that you were not given a hearing, because you started or you initiated the action to cross carpet on your own. But in this instance, the mere filing of the what's it called, the processes to contest as an MP, either independently or on a ticket of a political party, does not warrant for what's it called, the speaker to declare the seat vacant. So you should have given them the hearing, as Prof rightly stated. And then it's a very cardinal principle in law. You may have all the case, as in the fact of the case may be in your advantage, but then the fact that you did not give them a hearing, everything will crumble
down. But the argument to politically is that these are representatives of the people who came to the legislature on a party ticket. We all know that. And now they have expressed their intention that they no longer will be there. So in their constituency, they are there campaigning against that political party's candidates that they have put forward. So now you have moved from the realms of law and you're looking at reality.
So let's read the Article 97 GH. Article 97(1). A member of parliament shall vacate his seat in parliament if he leaves the party of which he was a member at the time of his election, or at the time of his election to parliament, to join another party, or seeks to remain in parliament as an independent candidate. Look at the wording. That you went to parliament on the ticket of party A. Then when you entered parliament, you said, no, I cannot do business with you. I would want to remain as an independent, independent candidate. Then automatically you've lost your seat. But in this instance, I have declared my intention to contest as an independent party, because I felt that during the primaries, my party could have done better, but then there were some mafia works somewhere. But still, when I go to parliament, I still side with them. So how can you, or how are you going to tell me that he has crossed carpet or vacated his? No. So until that, when he goes to parliament, he will inform that, oh, I don't want to do business with you. I want to join this caucus. That is when you can validly say that, yes, you've crossed carpet from party A to party B. So per the totality of what has happened, then your seat may be presumed to be vacant. And then look at the G2. If he leaves the party of which he was a member at the time of his election to parliament to join another party, or seeks to remain in parliament as an independent member. You see, both the what's it called? The
G and H.
The G and H. Okay, the H. If he was elected as a member of parliament as an independent candidate and joins a political party, so they are both talking about the same
So like Doc said, there's no ambiguity at all with this particular provision in the Constitution. Okay, let me go to Doc. Doc, let me come to you online. I know with your students that you have, and I can say you are a political historian. Have we been here before in our history? You know, everything there is the spirit and letter of the law. Have we been here before?
Not that I recall. I just can't recall any such case that we found ourselves in before. And actually, if we were, I don't think we'd be here now. We would have moved on.
Because there would have been something to learn from.
Yeah, some people believe that what happened and then Professor Okrah on when he was the speaker is a similar case. Some people believe that is a similar case. We had someone, declaring his intention to contest in the election as an independent candidate, and then it was interpreted to mean that he had left the party. If people, bring that issue closer to this one and say that they are similar, I will not dispute it. I will not dispute it. Yeah.
So, do you think the provision as it stands now is futuristic? It doesn't apply to the parliamentarians currently, those who went on the ticket of their parties?
That is one of the arguments that Professor Azar raised that I find problematic, because the moment you say it's futuristic, you are introducing time into the interpretation of this particular provision, and time is a variable. It will make the interpretation of this provision, inconsistent with time, and that will mean that you are introducing biases. You are being political. The moment you do that, you are introducing something extraneous. Let's read the G. It doesn't make mention of any time factor. It should be taken as it is. I use the expression a common sense interpretation. You don't have to bring in extraneous elements in an attempt to understand this particular provision. That is my understanding. Time should be taken out. The moment you say that it's futuristic, your actions, we are also bringing in intent. That is motives. Motives should not be brought in. The provision doesn't speak of any such thing. It speaks of actions and their interpretations. If he leaves the party of which he was a member, that is an action, explicit action, at the time of his election. If he leaves the party, so the crux of the matter here is leaving one's party. So we need to make a determination as to whether the 4 people who are affected have left their party. The issue as to whether they are going to contest in future elections is immaterial. It's immaterial. It's extraneous. The issue as to whether they are going to contest in their action today is, to facilitate their desire to contest in elections tomorrow to become a member of parliament in future on the ticket of is futuristic, is immaterial. The provision is not interested in that. This is explicit in black and white. You lose your seat if he leaves the party of which he was a member at the time. So the emphasis here, the focus is the action of the individual member, and then after the action, the locus of that person. Are they still members of the party that brought them into the parliament at this material moment in time? Are they there? Have they left their party? I think this is the determination that we are all looking forward to making or hearing.
Great. Let me come to you, lawyer Hafiz. Your final words on conversation this afternoon.
Okay, so I would end by saying that tomorrow cool heads should prevail. If 2 arms of government go at each other, it will erode the confidence the citizenry have imposed on such institutions. As we rightly stated, now the executive is gone. The judiciary also have their doubts. The only institution which we've banked our hopes on is Parliament, the legislature. So if the Speaker is to disregard the ruling of the Supreme Court, then confidence, total confidence in our judiciary will be gone. And then as they are legislatures, they make laws, and then they should know better about the impact or effect of such things. Exactly.
Okay. So. Doc, your final words. At least you sounded hopeful. I lost it, but you've given hope for tomorrow. What are your final words? One, I have a problem with this, suggestion that people have lost confidence in the executive. They have lost confidence in the parliament. I have a problem with that. If some people have issues with Nanado's leadership, it should not necessarily affect the office of the political executive. It should be possible for us to know the difference between the two. You see, historically, two Asante Hines have been disturbed before, historically. But the people who initiated the procedure that eventually succeeded in installing Asante Hines maintained their faith in the golden stool. They joined in the processes to install a different person. They had confidence in the system, and they worked at it. In fact, interestingly, this issue has something to do with my PhD thesis, examining the Kenyan state as to whether it is legitimate or... No, we have just a minute to go. So if you, So all I'm saying is that we don't necessarily have to lose confidence in the executive. We might not have confidence in Nana Dankwa Akufo-Addo because he said so many good things and did so many bad things in the political office. It's fair for people to lose confidence in him, but we shouldn't lose confidence in the office of the political executive. That will not be helpful for us. So thank you very much, gentlemen, for being with us on the show. We've had in the studio private legal practitioner Saeed Hafiz, and then online Dr. Kwesi Amachi-Boateng, who is a senior lecturer at the Kwame Nkrumah University of Science and Technology Teachers. Thank you very much, gentlemen, for we've been looking at the 4 seats that have been declared vacant. Viewers, tomorrow Parliament is in session. Parliament resumes tomorrow. All I have to say is that the 3 arms of government, the legislature, the executive, and the judiciary, are not rivals. They are partners in the pursuit of justice and peace. Keep the conversation going. I'm back on Wednesday on your screen. See you.